Yeah, please, Your Lordship. I beg to mention item number 2. The conducting council, I'm for the respondent. The conducting council is out of station. Matter may pass over for the day.
We'll adjourn it for 2 weeks then.
Lordship.
On the request of, what is your name?
Ms. K. Bhattacharya,
Ms. K. Bhattacharya, learned counsel appearing for the appellant.
respondent.
You are for the respondent,
Yes, thank you.
appearing for the respondent, made with the consent of the other side. Hearing of this appeal stands adjourned for 2 weeks. List accordingly.
Supplementary list for hearing part of matter item 6 and 7.
Yesterday I have concluded, but I have prepared one synopsis of my submission question. May I hand it over to the Lord?
I will share.
And yesterday also, Lordship, just I have pinpointedly point out one point, Lordship, one submission, Lordship. May I place that point, Lordship? Here, the confessional statement was made by accused Ahun Wangsa and co-accused Nitin against him, whether the confessional statement of Ahun Wangsa can be used against co-accused Nitin Das. Whether that point, Lordship, already your Lordship has decided in Ashwini Kolita that my learned senior court has already placed before Lordship. That is in paragraph 79 and 80 of that judgment, Lordship. It is already there. Ashwini Kolita, GLT reported in 2022. GLT.
In paragraph
79 and 80, Lordship.
Yes.
The next issue that arises for decision in this court, in this case, is as to whether the confession of the co-accused could be used as per section 30 of the Evidence Act for conviction of the accused in this case. Section 30 of the Evidence Act provides as follows. Section 30, consideration of proof confession affecting person making it and others jointly under trial for same offense. When more persons than one are being tried jointly for the same offense and a confession made by one of such persons affecting himself and some other of such persons is proved, the court may take into consideration such confession as against such other persons as well as against the person who makes such confession. Paragraph 80. In the case of Nolini, the Honorable Supreme Court had the occasion to interpret Section 30 of the Evidence Act. While dealing with the postulates of the Section 30, the Supreme Court has made the following observations in paragraph 685, which is reproduced below. 685. A plain reading of Section 30 of the Evidence Act discloses that when the following conditions exist, namely, more persons than one are being tried jointly. Number 2, the joint trial of the person is or the same offense. Number 3, a confession is made by one of such persons who are being tried jointly for the same offense. Number 4, such a confession affects the makers as well as such persons who are being tried jointly for the same offense. And number 5, such a confession is proved in court. The court may take into consideration such confession against the maker thereof as well as against such persons who are being jointly tried for the same offense.
Yes,
And I have given the submission, written submission, Lordship, which shows that intimating materials against the appellant's, Lordship. And those are not disputed by them. Lordship.
yes.
I have already written.
Anything else you want to say? Yes,
May I please, Lordship? The matter, again, coming to one point, is a confession. And this Oshini is, Oshini Kolita decision, Lordship, at page 65, paragraph 65.
Mhm.
Lordship observed, second part, Lordship, third sentence, sorry, third or fourth sentence. What would, however, be of utmost significance for the court to assess is to whether the confession has been recorded in compliance of the procedure laid down in section 164 CRPC, and also whether the same is voluntary. So, first part is whether 164 statement, confession recorded under section 164 CRPC has been recorded as per the provision once of section 164. That is to be satisfied first. Thereafter, all thing that is voluntariness, truthfulness. The first test is the whether it is as per provision of law. Now, it takes me to again section 164 to subsection 2 and subsection 4.
CRPC. In fact, why don't we read section 164?
Yes,
once
Lordship,
again, huh?
that is right.
Yes.
Section 164, recording of confessions and statements. 1. Any metropolitan magistrate or judicial magistrate may, whether or not he has jurisdiction in the case, record any confession or statement made to him in the course of an investigation under this chapter or under any other law for the time being in force, or at any time afterwards before the commencement of the inquiry or trial. Provided that any confession or statement made under this subsection may also be recorded by audio, video, electronic means in the presence of the advocate of the person accused of an offense. Provided further that no confession shall be recorded by a police officer on whom any power of a magistrate has been conferred under any law for the time being in force. Subsection 2. The magistrate shall, before recording any such confession, explain to the person making it that he is not bound to make a confession, and that if he does so, it may be used as evidence against him. And the magistrate shall not record any such confession unless, upon questioning the person making it, he has reason to believe that it is being made voluntary. Subsection 3. If at any time before the confession is recorded, the person appearing before the magistrate states that he is not willing to make the confession, the magistrate shall not authorize the detention of such person in police custody. Subsection 4. Any such confession shall be recorded in the manner provided in section 281 for recording the examination of an accused person, and shall be signed by the person making the confession, and the magistrate shall make a memorandum at the foot of such record to the following effect. So, I have explained to name that he is not bound to make a confession, and that if he does so, any confession he may make may be used as evidence against him. And I believe that this confession was voluntarily made. It was taken in my presence and hearing, and was read over to the person making it and admitted by him to be correct, and it contains a full and true account of the statement made by him. This up to this is regarding confession. Next is now subsection 2 and subsection 4 clearly says it has to be explained, and subsection 4 mandatorily says this memorandum has to be recorded at the foot of the record, confessional statement, which says I have explained. And all the decisions says
these subsection requirement of subsection 2, 3, 4 are mandatory in nature. Mandatory in nature. In our case, the exhibit 10, page 126 is the memorandum. Magistrate recorded, I have examined, not explained.
So this word examine appears to be a typographical error. It doesn't fit into this statement. I have examined Sri Var that he is not bound to me. It should have been I have explained to Sri Var. What is there in the original? Do you have the record? Just have a look at it.
Yes.
This is the photocopy. This is a
It is photocopy of the original letter.
photocopy. That's all right. The word examine does not fit into this sentence.
That means that it is erroneous. That means it is erroneous. So we cannot take it as a typographical error because person is has been convicted. Now, why I am saying so? It is Lordship may kindly come to the 124, page 124. The questions put to him.
Yes.
He was not put this question, or he was not stated that this, if he makes confession, it will be used against him. Question number 1, whether you are married or not. Question number 2, what is your source of income for survival, or whether the income is sufficient for family expenses or not? Do we know I am not a police person but a magistrate? Whether the police or any other force you to confess before the magistrate? Why do we want to confess? Do we know you are not bound to confess? One part is there, second part is not there. And that is why deliberately magistrate did not ask this, explained it. That's why my humble submission, what I understand, that she wrote it examined.
Acha, in the cross-examination of the magistrate,
Lordship.
was any suggestion made that she never explained to the accused the consequences of recording a confessional statement?
Lordship, my humble submission, it is not there, but prosecution has to stand on their own leg. However, on the weakness of defense, it cannot be. Secondly, it is a document. Confession, it is unlike this 164 statement of witness. It becomes a document.
No, you see, the magistrate has clearly deposed that she has explained. And that deposition substantially finds corroboration from the certificate issued by her. So after that, if the defense side does not challenge it, how can the court presume that it was not explained? That's the question we are asking you.
Yes, Lordship, it is not required because court could have taken this as per section 463. My place is at 463 only.
Let us see
463 CRPC is the power of the court to take this oral evidence, oral explanation.
Let us read 463.
Non-compliance with provision of section 164 or section 281. If any court before which a confession or other statement of an accused person recorded or purporting to be recorded under section 164 or section 281 is tendered or has been received in evidence finds that at any of the provisions of either of such sections have not been complied with by the magistrate recording the statement, it may, notwithstanding anything contained in section 91 of the Indian Evidence Act, take evidence in regard to such non-compliance and may, if satisfied that such non-compliance has not injured accused in his defense on the merits and that he duly made statement recorded and admits the statement. So any defects is curable under this 463. Now comes Lordship Dhananjay Reddy decision. If had the defect been not been a mandatory non-compliance of mandatory requirement, Honorable Court could have taken this oral part. Because 463 empowers, it is an exception to section 91 of evidence that exclusion of oral evidence of contents of the documents. Confession is a document. Now, Lordship, my compilation, this Dhananjay Reddy decision. It's starts from page 23. Relevant part is at page 32 of my compilation.
Page 32.
Page 32. Paragraph 20 to 22. Paragraph 20.
You have already placed it.
Yes, it's true.
Then,
That is, first said, this is mandatory requirement. Or,
no, that's all right. What we are asking, you have already placed
Yes,
this.
yes,
Now you want to push it.
no,
through
no,
into
no,
the
see,
mind
I'm
of
just,
something.
I'm just.
We don't forget arguments. We have noted it.
Here it is says that 460, it is not curable even under section 460 CRPC.
But that's all right. Don't repeat an argument you have made. We take note of what you
I
said.
am just linking Lordship this 460. Now, my humble submission would be if this question of this explaining is not also recorded, apart from defect in the memorandum,
Hmm.
so it cannot be said this is voluntarily. That's why in his V13 statement, he says, I do not know anything. I do not know. And once he says it is not a fact. And in the 313 also, Lordship, this particular question that the magistrate has stated before the court, she has explained to you such and such things, that question was also not. So in that view also it
No,
cannot
no,
be
you see,
taken.
Mr. Prokasta, if you argue on matters which are in conflict with the established principles, then you have to back up your argument with authority. In 313 statement, only the incriminating circumstances are required to be put to the accused.
Yes,
The fact that he was explained is not an incriminating circumstance. It is about the procedure followed by the magistrate while recording the statement. This is not something which the court was required to put to the accused. Of course, if the court did not put to him that he had confessed before the magistrate by admitting his involvement, then it would have had a significant bearing.
that part is there.
But whether it was explained or not, how these things will come in 313 statement? These
Because
are not,
because
these we'll see from the record.
that's it.
Huh?
I am submitting this because Lordship,
Hmm.
now that she has taken in, she has stated in her statement that she has explained the consequences.
Hmm.
That is,
That's right. So you have argued that. We'll
yes,
consider if there is any new point you want to make, or even on this, then you say, but there is no point repeating.
yes,
Your argument is that there has been non-compliance of section 164(4).
four,
And the reason is it was not explained to the accused
seconds.
that it will be used as evidence against him. There is a certificate which says examined.
Lordship.
If you replace the word examined with explanation, then it fits into the entire statement. But if you put the word examine, it does not have any relevance with the entire certificate. So we will see whether it is a case of, whether it can be interpreted as a case of a typographical error, or it can be read as a defect in recording of. We will consider that.
Lordship.
And if it is a defect, then the statement will not be admissible. It goes, if it is not accepted as a defect, and then other requirements are complied with, and the court holds that it is admissible, then the matter will proceed on the basis of the statement. That is the long and short of the matter,
Lordship.
is it not?
Lordship.
So if you want to argue on any new angle in reply to what they said, you argue, we'll take note. But don't repeat the arguments you have made.
I have submitted
That
this,
is
Lordship.
not required. We don't forget what has
Yes,
been argued.
yes.
Don't presume that we forget.
Uh,
Yes,
I have submitted because learned counsel for the state.
Yes, what is the next point, Mr. Prakash? What is the next
That
point?
relied upon the decision that
Which decision?
2025 SCC 782.
Right.
Regarding this decision says subsequent part, Lordship, that my first argument has not been touched.
Mhm.
And in this decision, these two decision, Dhananjay Reddy decision is not also discussed.
Mhm.
Here, Dhananjay Reddy case has not been discussed, and this particular question of law has not been discussed. Awesome. Identification.
Yes.
Now. Regarding evidence of TW8, regarding identification, query was put, Lordship. CCTV footage also I argued yesterday.
Mhm.
CCTV footage,
Mhm.
I argued that it is not there. And regarding oral evidence of PW8 of seeing through CCTV footage, whether it can be taken into consideration. It cannot be because CCTV footage is like a document, electronic records. Section
So you are repeating the arguments you made in the.
Section 59 of evidence set. I'm referring to section 59 of evidence set only, Lordship.
Mhm. What does it say? Let us see. 59.
Proof of facts of oral evidence.
Yes.
Proof of facts of by oral evidence. All facts except the contents of documents or electronic records may be proved by oral evidence. What has been seen in CCTV footage, it is the contents of the CCTV footage. Unless the CCTV footage is produced.
See, there is no CCTV footage.
Yes. Lordship.
But he says this is the way he came to the conclusion that it was the accused. That is his oral evidence,
Yes.
which has remained unrebutted. We will deal with the oral evidence. We have been telling you since yesterday. You are again and again going to the CCTV.
I am trying to submit.
We don't know whether there was a CCTV footage or not.
Yes.
But he says this is the procedure I applied to come to a conclusion that this person was the one who had thrown the acid. That is his oral evidence.
Yes.
That evidence is on record.
On record.
We will see how this evidence is to be acted upon. When the CCTV footage is not there, is not there. What is the point in telling this 10
My
times?
answer to this, Lordship,
Yes.
his statement is that through CCTV footage, I have come to know.
If your argument is unless the CCTV footage is placed, he cannot even depose in the court, or
But
that will be
this-
inadmissible.
Yes.
Then you show us a judgment.
It is section 59. It says oral evidence cannot be given unless this and read with section 91 of evidence of counsel.
No, all right, all right. We have taken note.
CCTV footage. CCTV footage.
Something which is not there is not there. As simple as that.
Yes, yes.
That is gone. But he said something. He could have said, I saw it from CCTV footage. I saw it in my dreams. I heard from someone. We will see what is the probative value of his evidence. If without the CCTV footage, his oral evidence stands and is found to be admissible, it will be treated as admissible. You argue on that his oral evidence is inadmissible and argue on that. Instead of doing that, you are again and again saying,
Lordship, what I am back to submit again, what I am back to submit that this particular oral evidence is based on CCTV footage.
so therefore, unless the CCTV footage is seized, his evidence is inadmissible.
Yes.
Show us that.
It is section 59 says, the
Sorry.
contents of a
Section
document or
59.
electronic record cannot be
No, it's not
proved by
about,
oral evidence.
nobody is asking for proof of CCTV. The question here is of his oral evidence. We are not even bothered about the contents of the CCTV footage. Mr. Purkasto, you are a sufficiently experienced person. Why do you
I-
get
I
stuck
will-
up in areas which
I
are
will-
irrelevant?
Although Lordship, I have not submitted any decision in this regard. I will submit a decision. I will,
Today we'll close the
today-
matter.
but today I will
We've been
submit
hearing
it,
it since there 3 days. We'll.
no, I am not seeking an adjournment. I will submit a decision on this point only.
Yes,
Yes.
if your case is that this witness has said that this is how he has come to a conclusion, his oral evidence is inadmissible unless the CCTV produces, the footage is also produced.
Yes.
If you can convince the court on that, then obviously it's a arguable point.
That is my.
But you are again and again saying he
That
has
is
said
my
this,
submission. Lordship.
but the CCTV, but submission will not do. You convince us that that's the law.
From section 60, section 59.
All right.
I'm
So if
developing
your
this
argument is that because of section 59, it cannot be done,
Cannot.
we'll deal with it accordingly.
Yes.
That's all. We'll deal with it. But we can tell you right now that argument cannot be accepted. 59 deals with oral evidence. Any person is entitled to state facts which he has seen, which he has heard in his oral evidence, unless it is challenged or anything is shown to conclude that this is not admissible. How can we throw away the oral testimony? Of course, what effect it will have ultimately, what probative value his evidence will have, that is another matter. We are on you are arguing on inadmissibility, but you are not bolstering your argument with any legal proposition. If the CCTV footage was brought in without exhibiting, and you want to say that it is inadmissible, then we can understand it. CCTV footage is nowhere in the picture. There is no CCTV footage, but he says this is the reason why he thinks this was the person. You have not assailed his deposition during trial in cross-examination, and you are telling us to disbelieve it or discard it. You tell us the principle, we'll do it, we'll consider it.
On the basis of section 59, I am submitting this.
All right.
Yes,
Then
yes.
you may not labor on this point.
Yes.
You can move on.
Yes. Confusion. Now, I have referred in my this compilation one decision that prosecution has to stand on their own legs on the witness. It is
These
there,
are-
search and the vigility, it is there.
These are established principles.
Yes.
There is no
Okay,
need
absolutely.
to labor on these areas.
Yes.
Charge has to be proved, obviously,
Yes.
and proved beyond reasonable doubt.
Absolutely.
Is it beyond reasonable doubt or beyond all reasonable doubt? What is the law?
Beyond all reasonable doubt.
All reasonable doubt.
All reasonable.
Where do you find that? Beyond all reasonable doubt? Mr. Chaudhary, is it beyond reasonable doubt or beyond all reasonable doubt? All reasonable doubt. Is there any judgment which says it should be beyond all reasonable doubt? Can you remember?
Right now, I don't remember.
Yes, Mr. Ahmed, is it beyond reasonable doubt or beyond all reasonable doubt? Not all reasonable doubt.
On all what is not available, madam. Only beyond reasonable doubt. Judgment I have.
Probably you're right. Yes,
This much is my mission. This much lordship, I am answer. There is nothing else. They cannot stand on our weakness. With cross-examination done. Legally has to be proved. This much.
Just a minute. Mr. Purkasta, you see, you are arguing a matter before the division bench of the High Court. These are serious matters, heinous offense. There are certain basic principles which, if a counsel is not clear, it becomes very difficult for the court to communicate. You see, loopholes of the defense side obviously cannot be a ground for the prosecution to claim that charge has been proved. There is no doubt about it. Those loopholes could be the failure of the defense side to speak or clarify on an issue, the accused remaining silent, not adducing evidence in defense. These are the areas where this principle applies. But when you come to examination of witnesses, and there is a mechanism of cross-examination, when in the cross-examination, some statement of the witness is not challenged, then can he later on say that this statement is not correct? Even though I did not challenge, the court should take it as not correct. Is that the law?
It has effect, Lordship, it has effect.
No. What is the law we are asking you? What is the law?
It has to be contradicted or denied in the, mere
So
denial
if-
is also not enough. Mere
If it
denial
is,
is also
if it
not
is
enough.
not contradicted, then can the court, can the defense say that this particular statement of a witness which supports the prosecution story, even if not challenged, should be discarded? And there is no reason for it. Only thing is that prosecution cannot, it was a lapse on the part of the defense, but prosecution cannot rely on the lapse of the defense. Is that argument
No, Lordship,
maintainable?
it cannot be, I am not arguing also this.
Then
But
what is your
But
argument?
because in this case, there is no eyewitness. PW1 is an informant, 2, 3, 4, 5 are also injured, they did not see. 7 is the IO, 6 is Manai Wangsa, his evidence goes. And 7 is the IO, 8 is this person, there is Anaruddin, there is the main
So you
victim.
are saying that unless there is an eyewitness, there can't be conviction.
Circumstances have to be proved. Every link has to be, chain is to be linked to form a full complete chain. Otherwise, it cannot be.
So in this case, which is that link in the chain which has not been proved according to?
First confessional statement. First confessional statement, it is not admissible in evidence.
Hmm.
First, if confession and admission goes, there is no other evidence, only PW8, CCTV footage, it is not there. Evidence, his deposition or statement based on CCTV footage, it is my humble submission, it cannot be taken into consideration. There is nothing else.
All right. All right. That's all.
Yes, sir.
Anything else you want to argue?
Yes, Lordship.
Mr. Chaudhary, you want to add something?
My lord, against Nipin Das, there is only, my lord, the evidence of, my lord, the evidence of confessional statement of co-accused. Rest of the, my lord, the circumstances which are taken, as I referred yesterday, para 66, my lord. Those have not been proved, my lord, legally. And my lord, regarding the first three circumstances regarding the motive, my lord, that may I just, my lord, point out that, my lord. The circumstances as shifting of mobile phone, mobile shop of Anaruddin by Anaruddin near to accused Dipen Das's mobile shop even after the execution. The next is, my lord, threatening by accused Dipen Das regarding future problem to be faced by him. And number 3 is, my lord, difference between the both accused and victim. These 3 are the, my lord, taken as the, my lord, motive. But in, my lord, cross-examination of Anaruddin, my lord, just may I point out that, my lord.
That is PW8.
PW8, my lord. At page number 24. Cross-examination, my lord, first line. At page
Yes.
24.
Yes.
Since about 2010-11, I know Nipin Das. Before the incident, there was no quarrel between me and Nipin Das. And he has not given me any intimidation. I have seen one underground person who came to the residence. Nipin Das dropped me at his village by his. Nipin Das did not threaten me to do partnership business with him. These are, my lord, the thing. That he didn't give any, my lord, intimidation or threatening, etc. So, my lord, the whatever he has stated in the evidence, learned quote below, my lord, they have taken these circumstances as the motive that we had got enmity. I had given threatening. Not taken into account. This cross-examination part has not been taken into account, my lord. And his brother also, my lord, the next PW9, he has also stated, my lord. I cannot say that Nipin Das threatened my brother through me for not opening mobile shop.
27.
So, my lord, their inimical relations prior to the incident, that has gone, my lord, from the cross examination of these two witnesses. So, my lord, that motive also goes, my lord. So, only remain, my lord, is now the, my lord, the confession of the co-accused. Whether, my lord, court can start with the, my lord, confession of the co-accused. Harisharan Kurmi's case, my lord. First, court into look into other evidence, my lord. Finally, if court is, my lord, convinced, then only, my lord, court can look into, my lord, the confession of the
That
co-accused.
judgment is here.
Yes, my lord, I have given, my lord. 1964 Supreme Court 1184. Knowledge the literature there. Para 13, madam.
Just a minute. Para 13.
Para 13, madam.
Yes.
As we have already indicated, this question has been considered on several occasions by judicial decision. And it has been consistently held that a confession cannot be treated as evidence which is a substantive evidence against a co-accused person. In dealing with a criminal case where the prosecution relies upon the confession of one accused person against another accused person, the proper approach to adopt is to consider the other evidence against such an accused person. And if the said evidence appears to be satisfactory, and the court is inclined to hold that the said evidence may sustain the charge frame against the said accused person, the court turns to the confession with a view to assure itself that the conclusion which it is inclined to draw from the other evidence is right. So thereafter, my lord, some of the decision of the, my lord, this Privy Council, etc., has been, my lord, apart. As was observed by Justice so-and-so in Emperor versus so-and-so, a confession can only be used to lend assurance to other evidence against the co-accused. In Peruaswamy Mopan, Really Judge observed that a provision of section 30 goes not further than this, where there is evidence against the co-accused is sufficient, if believed, to support his conviction, then the kind of confession described in section 30 may be thrown into the scale as an additional reason for believing that evidence. In Bhuvani Sahu versus King, the Privy Council has expressed the same view. Sir John Newman, who spoke for the board, observed that a confession of a co-accused is obviously evidence of a very weak type. It does not indeed come within the definition of evidence contained in section 3 of the Evidence Act. It is not required to be given on oath, nor in the presence of the accused, and it cannot be tested by cross-examination. It is a much weaker type of evidence than the evidence of an approver, which is not subject to any of those infirmities. Section 30, however, provides that a court may take the confession into consideration and thereby no doubt makes it evidence on which the court may act. But the section does not say that the confession is to amount to proof. Clearly, there must be other evidence. The confession is only one element in the consideration of all the facts proved the case. It can be put into the scale and weighed with the other evidence. It would be noticed that as a result of the provisions contained in section 30, the confession has no doubt to be regarded as amounting to evidence in a general way, because whatever is considered by the court is evidence. Circumstance which is considered by the court as well as probabilities do amount to evidence in that generic sense, Thus, though confession may be regarded as evidence in that generic sense because of the provision of section 30, the fact remains that it is not evidence as defined by section 3 of the Act. The result, therefore, is that in dealing with a case against an accused person, the court cannot start with the confession of a co-accused person. It must begin with other evidence adduced by the prosecution, and after it has formed its opinion with regard to the quality and effect of the said evidence, then it is permissible to turn to the confession in order to receive assurance to the conclusion of guilt which its judicial mind is about to reach on the said other evidence. That briefly stated is the effect of the provisions contained in section 30. The same view has been expressed by this court in Kashmira Singh versus State of Madhya Pradesh, where the decision of the Privy Council in Bhuvani Sahu case has been cited with approval. Then, my lord, paragraph 17, my lord.
Yes.
It is true that the confession, it is related to this case, my lord. It is true that the confession made by Ram Surat is a detailed statement and it attributes to the two appellants a major part in the commission of the offense. It is also true that the said confession has been found to be voluntary and true so far as the part played by Ram Surat himself is concerned. And so it is not unlikely that the confessional statement in regard to the part played by the two appellants may also be true. And in that sense, the reading of the said confession may raise a serious suspicion against the accused. But it is precisely in such cases that a true legal approach must be adopted, and suspicion, however grave, must not be allowed to take the place of the proof. As we have already indicated, it has been a recognized principle of the administration of criminal law in this country for over half a century that the confession of a accused person cannot be treated as substantive evidence and can be placed into service only when the court is inclined to accept the other evidence and feels the necessity of seeking for an assurance in support of its conclusion, deductible from the said evidence. In criminal trials, there is no scope for applying the principle of moral conviction or grave suspicion. In criminal cases where the other evidence adduced against an accused person is wholly unsatisfactory, and the prosecution seeks to rely on the confession of a co-accused persons, the presumption of innocence, which is the basis of criminal jurisprudence, assists the accused persons and compels the court to render the verdict that the charge is not proved against him, and so he is entitled to the benefit of doubt. That is precisely what has happened in this appeal. Here, my lord, this both the appellants, my lord, they were acquitted, my lord, because there also only this confession of co-accused was there. So my humble submission before your lordship is that, my lord, against this accused appellant, my lord, except this, my lord, confession of the, my lord, co-accused, there is nothing, my lord. So I pray, my lord, on this score only, my lord, who may be acquitted, my lord. I'm obliged.
May I please your lordship, my lord? Your lordship kindly look to the, my lord, court witness E.P. Kapoor, my lord. One part, my lord. I give you my lord clarification. What my understanding has argued, my lord, before you are not able to, my lord. He said on the fourth line, I have recorded the confessional statement of accused Ahung Wangsa as provided 164 CRPC. Before recording the statement, I made accused person to understand that I am a magistrate, he is not bound to confess. I have also made understand that the confessional statement, if deposed, will be used as a piece of evidence against during the trial. Meaning the understanding explanation, my lord. Other way, my lord. And when it was cross-examination, my lord, it was stated that I have repeatedly asked to whether he is confessing voluntarily. On being satisfied that confession was made voluntarily by the accused, I proceed to the recording the statement. That is available. And one thing is that, my lord, explanation word, my lord, if your lordship made a set, my lord, within the domain of examination. Without explanation, my lord, how can a person examine, my lord? That is available. One thing is important, my lord. Yesterday I argued, my lord, in respect of the, my lord, court test number 1, the content of the evidence of Manai Wangsa, not evidence, 164 statement has been, my lord, proved before the court, my lord, giving all the statement. And in cross-examination, they did not deny the statement of Manai Wangsa. If your lordship goes to the 281 CRPC, my lord, that is admissible.
Was his statement exhibited?
That statement was, my lord, content of the statement was, my
No,
lord,
no,
mentioned.
then please don't get into that.
My lord,
Statement was not
exhibited, my lord.
by whom?
By the, my lord, that magistrate, my lord.
Are you, lordship? Are you?
No, magistrate.
But are you then here?
No, magistrate.
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 Say exhibit 9.
Exhibit 9 is the statement of Manai Wangsa recorded by me.
That's correct, but he did not go by his statement recorded under 164, Manai Wangsa.
Manai Wangsa statement, my lord, before the court, that time was not exhibited, my lord. Subsequently, when magistrate has come, my lord, it was exhibited, the content was proved. My humble submission before your lordship is that Manai Wangsa content, which has been, my lord, mentioned, but he stated, that was not denied by the, my lord.
Oh, Mr. Chaudhary, 164 statement is not substantive evidence.
I know, my lord.
So then what value it has?
This one.
The witness
And
did not
the-
support the prosecution case.
Manai Wangsa's.
You have to forget him.
Yes, ma'am.
You can't rope him in for any purpose. He's gone. You have lost him.
Yes, ma'am.
Let him rest there.
Yes, ma'am.
There's nothing you can do about it now.
A Manai Wangsa statement has been corroborated by the, my lord, statement of PW8, my lord. That is why I am saying. And one thing is that, my lord, my learned friend has said, in chief he has said, my lord, Nipen Das, one day came me and asked me not to open the shop here. He rather asked me to open grocery shop and showroom. I did not agree the proposal of Nipen Das. After a few days again come for opening partnership shop. That partnership shop has been denied. Other part was not denied, my lord.
So although there is no reply to reply, but since you have stood up, what do you have to say to Mr. Chaudhary's argument that except the confessional statement of the main accused,
Yes, ma'am.
there is no other incriminating material against his client? What do you have
It's
to say?
available, my lord. And that is why I am reading, my lord.
What is available?
Yes, my lord. Available is that, my lord, he is threatening to close the shop, my lord. We open a grocery shop. Only he denied that partnership did, my lord. That is why I am saying. Your lord, kindly go to cross part, my lord. That is the, my lord, only that part has been denied. Police has taken statement, the incident, that only that part, my lord. That Nipen Das drove his village by his motorcycle. Nipen Das did not threaten me to do partnership business. Only that part denied. Earlier part for closing the shop and other part was not denied. That is my humble submission before your lordship. And other part, my lord, IO has seized the mobile phone and others, my lord. That was also not denied by them, my lord, in the cross-examination. Page 89.
That IMA number is not there. Seizure of that mobile.
They
First
took,
thing,
let him come. Maharaj, they took the advantage of defective part of the investigation. I can produce, my lord, ample judgment, my lord. Defective part of the investigation, my lord, they cannot get, my lord, acquitted. Today I did not brought that judgment, my lord. If there is some minor defect, my lord, for that, my lord, they cannot, my lord, get acquitted, my lord. There is ample judgment, my lord. If necessary, I shall give.
All right, so that's all. We'll close it.
my lord.
We take down heard Mr. S. D. Purkayastha, learned counsel appearing for the appellant in Criminal Appeal 97 of 2021. We have also heard Mr. B. M. Chaudhary, learned counsel appearing for the appellant in hit case of appeal. Full stop. Mr. N. N. B. Chaudhary, learned public prosecutor, Government of Arunachal Pradesh, has appeared for the state, whereas Mr. A. Ahmed, learned counsel, has appeared for the victim. Victim, he is the informant. Victim stroke. Victim and the informant, full stop. Arguments concluded, judgment reserved.
We have also given them a written synopsis, my lord.
All right.
Before Lordship close, just may I point out one thing, Lordship, not regarding that merit of the case. Here, Lordship, regarding compensation, Lordship, that part.
Mhm.
It is directed to the accused to deposit Lordship the amount as a fine, Lordship. So may I pay that amount may be realized from the legal service authority, Lord. Legal service authority may be directed to pay that compensation amount, Lordship. I have just.
Legal service is decent.
legal service এ দিয়া নাই। হয়তো অৰুণাচল ষ্টেটৰ সেইটো সুপ্ৰিম কোৰ্টৰ জাজমেণ্ট আছে সেইটো মতে দিছে।
No, what is it?
Lordship,
Uh,
the judgment Lordship will find.
Point of sentence was a hit to order to. Hearing memo for person. The paper book nine. Paper book nine.
Give a note, Mr. Ahmed, give a short, give it to her.
And another aspect of it that regarding Horichara, already your Lordship has dealt with it in Ashwini Kalita case, Lordship.
Mhm.
That paragraph 6 and 75.
79.
Ashwini-
Original could be law is good law.
Yeah.
It's
that-
good law.
that-
Whether what applicability you will have in the facts of this case, we'll
Lots.
see. But it's good law.
Lordship.
Obligation.
Outline.
Daily list for hearing item 1.
Yes.
302 conviction, my lord. Before reading the evidence, my lord, in the three, may I point out, my lord? In the 313, my lord, he admits of having committed the act.
Mm.
Allegation is that he killed the husband of the PW1, my lord, the informant. Attacked him with a dao. Although in the FIR as well as in the PW1's statement, my lord, few others were also brought in, my lord, on the allegation that they had restrained the deceased, my lord. But the
But
others,
conviction cannot be awarded only on three.
no, not only on, but there are two eyewitnesses, my lord. May I just read the evidence part, my lord?
Let's see what is the error first.
Ejahar is at, my lord, page 4, my lord. FIR is lodged, my lord, 1 day after the incident.
Mm.
Humble submission is that around 2-3 p.m. on 7/5/2011, the above mentioned accused persons carried my husband and assaulted him with a dao together in a body. All the accused started assaulting him with dao and killed him in the place of occurrence itself. After I raised alarm, the neighbors rushed to the place of occurrence and the accused persons ran away. I became helpless with my 2 kids now. There is no other source of our survival in future. The witnesses who will give statement are Sorala Telly, so-and-so, and others. It is therefore prayed to take action accordingly. The FIR is registered on 8th month. Entered by Bilaipur OPGD number 99 dated 8/5 at 6 p.m. Registered and received and registered at Lala PS case number 65 of 2012. And date appears to be a typographical error, my lord, at page 5.
Mm.
It is 7/5/2011. It should be 12. It appears to be a typographical error.
It should be 2000.
12. my lord. But in the same mistake is there even at page 4.
Yes.
But the incident is of 2012. Now, my lord, PW1 is at page 9. She is the wife of the informant.
Mm.
About 3 years back in an evening at about 2-3 p.m., the incident took place. The house of the accused Jogoi Telly is situated on the bottom of the tila, and our house is on the top of the same tila. At that time, the accused Jogoi Telly from his house asked my husband to go to his house and accordingly my husband went to the house of the accused Jogoi, and then accused Jogoi alone assaulted my husband. Although in the FIR it is said that all of them accused, my lord. By means of a dowel, inflicting blows on the back of the head, and remaining accused persons encircled my husband. As a result of the assault, my husband fell down on the ground. When I went near my husband, I found him senseless. Accordingly, I raised hue and cry, and hearing the same, Sarala Teli and Vaikuntha Teli came to the place of occurrence and saw the incident. Thereafter, I lodged Ejahar Exhibit 1, so and so is my signature. Accordingly, police came to the place of occurrence, recorded statements of myself and others, and took the dead body of my husband. Police also took so and so and other neighboring people to the hospital. Doctor has declared my husband dead. I do not know the reasons why, my lord. One of the one thing, my lord, Lordship will kindly make a note, my lord. She says that she raised the hue and cry first, and then Sarala and Vaikuntha Teli came, my lord. Sarala Teli is her mother, and Vaikuntha is her father. And to get an idea, my lord, of the area, my lord, Lordship may kindly come to the trace map, my lord, at page 62.
Yes,
Now, B is the house of the accused, my lord, the petitioner before your lordship, appellant before your lordship, my lord. C is the house of the deceased, and D is the residence of Sarala and Basudev, my lord. And the incident, place of incident is at A. Just to have an idea. So she says that she had raised in hue and cry after seeing the incident. Then Sarala and Basudev comes, my lord. Now in cross-examination, page 10, my lord, I did not see the incident with my own eyes. Page 10. I did not see the incident with my own eyes. Accused Samru Teli is my grandfather. Accused Sodoy and Babul are my maternal uncles. Accused Jogoi is my brother, my lord. How she says this, I don't understand, my lord. He is not his brother. Accused Vijan is the husband of my cousin. My house is situated at a distance of 15/16 cubits away from the place of occurrence, towards top of the Tila. My husband came from his house towards the house of accused on being called by the accused. In my house, myself along with my husband and 2 children were residing at the time of incident. Meghnad Teli and my father were residing in the same house. The house of Lalmohan Teli is situated near the house of my father. After 5 to 10 minutes of my arrival at the place of occurrence, other people arrived at the place of occurrence. Police recorded my statement after 2 days of the incident. It is not a fact that whatever I have stated today before this court were not stated by me before police during recording my statement. I did not mention in the FIR as well as my statement recorded by police that my husband sustained injury on the back side of his head. It is not a fact that the accused Jogoi Teli did not call my husband to his house. It is not a fact that other accused did not carry out my husband. It is also not a fact that I did not see any injury on the deceased on arriving at the place of occurrence. Then, my lord, the next person is Sarala Teli, is the mother, my lord. PW1 is my daughter. I know the accused persons. About 4 years back, in an evening about 2 p.m., the incident took place. At that time, I was in my house. On hearing hue and cry, I came out of my house and saw the accused Jogoi inflicting blows by means of a dowel on my son-in-law. I also saw accused so-and-so, so-and-so, and so-and-so kept the deceased confined. Then I raised hue and cry, but none came to the place of occurrence instantly. But when the deceased fell down, receiving the said dowel blows, the neighboring people came to the place of occurrence. My house is situated at a distance of 4/5 nals away from the house of my daughter. Thereafter, my daughter lodged an ejahar. Accordingly, the police came to the place of occurrence. Until arrival of police, the dead body of my son-in-law was there at the place of occurrence. The incident took place in front of the house of Sodoy Teli. Police took the dead body and post-mortem examination was done on the dead body of the deceased. Later on, we received the dead body and performed the last rites. Cross-examination. There is a public path running towards north-south direction. I found the deceased on the road in front of the house of the accused. Hearing hue and cry at first, I rushed to the place of occurrence. After about 5 to 10 minutes of my arrival at the place of occurrence, other people came to the place of occurrence. One Corona Paul also came to the place of occurrence. I cannot recollect the names of other persons who also assembled at the place of occurrence at that time. My house is at a distance of 3/4 miles away from the place of occurrence. I saw that accused Jogoi inflicting 15 to 20 numbers of blows by means of dao on the deceased. Police recorded my statement on the date of occurrence. Subsequently, police did not meet me. It is not a fact that I did not state before the police that accused Jogoi Teli was inflicting dao blows on my son-in-law, and remaining accused persons kept my son-in-law confined, and the said fact is false. It is not a fact that I did not state before police that on hearing my hue and cry, neighboring people came to the place of occurrence. Some amount of discrepancies are there, my lord. Because the wife says that she saw the incident, she created a hue and cry, then the mother came. The mother says that no, she saw the incident.
Who are the eyewitnesses?
The 2, 3, and 4, my lord. Not 4, 2, 3, and 4, my lord.
And PW1 is the informant.
PW1 is the informant. But PW1 in cross says that she did not see the incident.
PW1 is also the wife of the victim.
A wife of the victim. The statements in the FIR and her statements before the court are contradictory. And PW1 and 2 says that the other persons were involved, but the other witnesses do not say so. They have been acquitted, my lord.
Yes.
Then, my lord, PW3 is the father, my lord. Oh, not the father, it's Boykuntha Teli, he is the son. I mean the brother of the informant. I know the accused persons. I also know the deceased who was the husband of my sister. PW1, about 1 year back at noon, at about 12:01 p.m., the discrepancy in the time, the deceased Dilip came from his house towards the bottom of the tilla, and then accused Jogoi inflicted blows by means of a dao from the backside of the deceased. As a result, Dilip fell down on the ground. At that time, I was in my house. On hearing hue and cry, I came out of the house. My house is situated at a distance of 2 miles away from the place of occurrence on the plain land. I saw the accused was inflicting dao blows on the deceased. At the place of occurrence, I found accused Jogoi, Bijan, Babul, and Somko at the time of occurrence. Accordingly, the accused persons left the place of occurrence. On being informed, police came to the place of occurrence and took the dead body. Police recorded my statement. Cross-examination. I found the deceased on the road, which is situated just downward from the house of the deceased. I found the deceased in injured condition. Before my arrival at the place of occurrence, my mother, sister were already present at the place of occurrence. If they were already present, my lord, he could not have seen the incident. Police did not record my statement. It is not a fact that accused Jogoi Teli did not inflict dao blows on the back of the deceased while he was coming towards from his house, and I did not see the other accused at the place of occurrence. It is not a fact that we lost the Ejahar falsely. It is not a fact that my father.
Is it a case of res geste witness?
It's-
Think about it while he finishes, you give your response. Yes.
And that's next, the PW4, my lordship may come to the PW4, my lord. I know the informant. I also know the accused persons as they are related to me. About 3 years back, Dilip Teli was murdered near the house of accused Jogoi Teli. At that time, I was in my house. My house is situated adjacent to the house of accused Jogoi Teli. During the hour at about 2 p.m., the incident took place. I saw the accused Jogoi committed murder of the deceased alone by means of dao. At that time, other accused persons were not present there. Totally different story, my lord. I also raised alarm at that time. After sustaining dao blow, deceased Dilip fell down on the ground. At that time, none came to the place of occurrence as the villagers were not present in their respective houses. Police was informed, and accordingly, police came to the place of occurrence, took the dead body, subsequently taken back, last rites were performed. In cross, he says, my lord, I saw accused Jogoi was committing murder of the deceased. I did not go to the place of occurrence out of fear. My place of occurrence, I think it should have been residence, is situated to the downwards from the house of Dilip. My house is situated at a distance of ½ kilometer from the house of Dilip. It is not a fact that accused Dilip did not kill the deceased. Informant is my niece. It is not a fact that for the sake of the informant, I have deposed falsely against the accused. It appears to be so. That they are interested witnesses, my lord. And his house is at half a kilometer away. How could he have seen the incident when he was in the house? And he says that I did not come out of the house. Basudev Teli, my lord, PW5 is the father of the informant. I know the accused persons. I also know deceased Dilip Teli, who is the husband of my daughter. About 3 years back, at the time of incident, I was in the house of ration dealer of my village, and at that time I heard some hue and cry, and accordingly I rushed to the place of occurrence and saw the dead body lying on the ground. At that time I found none except my daughter, who was crying there. I found the dead body about 2-3 miles away from my house by the side of the village path. I did not see the incident. Subsequently, I came to know from my daughter, the wife of the deceased, the accused Jogoi committed murder of the deceased by inflicting dog blows. My daughter so-and-so lodged Ejahar, and thereafter police arrived. Police investigated the case and recorded my statement. Police also recovered and seized the dhow in my presence. I put my thumb impression in the seizure of the dhow. Police brought the dead body cross manner. The house of ration dealer is situated at a distance of 30 to 40 miles away from the house place of occurrence. The place of occurrence is situated downwards from my house, from the house of Dilip Teli. At the place of occurrence, I found my wife, Sarala Teli, also. In the chief, he says that no one was there except his daughter. I did not find the accused persons there at that time. After half an hour, other persons gathered at the place of occurrence. I did not see the incident. I cannot say where from police took the dhow which was seized in my presence. It is not a fact that my daughter did not state before me that accused Jogoi so-and-so inflicted dhow blows on the deceased, and as a result, the deceased died. It is not a fact that I have deposed falsely for the sake of my daughter. Now, PW6 is the doctor, Mala. On 8/5, I was attached to Hailakandi Civil Hospital, and on that day, I performed post-mortem examination on police requisition of the dead body of so-and-so, ages 35 years. And on examination, I found the following: 1 incised wound size of so-and-so in the occipital region, 1 incised wound of size so-and-so above the wound number 1, 1 incised wound of size so-and-so in right infrascapular region, 1 incised wound of size so-and-so at the right ankle joint, incised wound of size so-and-so on the left ankle joint. There is cut injury of skull bone below the incised wound as described in injury numbers 1 and 2. There is cut injury of dura, arachnoid and diameter of brain with presence of extradural, subdural, superanchoid hematoma. There is a cut size of 1 cm, deep cut injury of brain matter, occipital lobe of brain with intracerebral hematoma. There are complete linear fracture of occipital, temporal and peritoneal bone. There are cutting of multiple vessels along the line of the incised wound. Exhibit 2 is the postmortem report, wherein Exhibit 2 is my signature. In my opinion, the death was due to irreversible hemorrhagic and neurogenic shock as a result of multiple incised wound on body caused by moderate, heavy and sharp object. Such type of injury will not occur if anybody falls from a height by rolling down. In that case, he will sustain injury in all sides of the body, not only in the backside. Now, PW7 is the IO. On 7/5, I was attached to Bilaipur outpost under Lala PS, and on that day, I received a telephonic message from one Basudev Teli, which is he is the father, my lord, to the effect that one Dilip Teli was murdered by Jogoi Teli, along with some other persons. Accordingly, I informed the matter to SP Hailakandi as well as OC Lala, and I made GD entry number 82, dated 7/5. Exhibit 3 is the said GD entry, wherein exhibit so-and-so is my signature. Thereafter, I went to the place of occurrence and I found the dead body of Dilip Teli there, and I also examined some of the witnesses. I also held inquest on the dead body of the deceased. Exhibit 4 is the inquest report. 4 is my signature. 4(1) is my signature. I also obtained signature of witness so-and-so, so-and-so. Are their signatures in Exhibit 4? I also drew up a sketch map of the place of occurrence. Exhibit 5 is the said sketch map, so-and-so. I also seized one dhow by Exhibit 6 from the place of occurrence. I described the dhow as blood-stained of length about 22 inch with wooden butt. Exhibit 6(1) is my signature. I sent the dead body to Hailakandi Civil Hospital for postmortem examination, and accordingly the postmortem examination was held. Subsequently, this may not be very relevant, my lord. Cross-examination. On 7/5/2012 at about 2:20 p.m., I got the information over telephone, and I reached at the place of occurrence at 2:55 p.m. I started the investigation of the case on the basis of GT entry number so and so. I also recorded the statements of Sorola Telly at the place of occurrence. Accordingly, I drew up sketch map of the place of occurrence on that day. As per the sketch map, the dove was recovered and seized from an open place. I did not send the said dove to FSL for chemical examination. I did not accompany the dead body to hospital in Ejahar. In Ejahar, there is no mention of any reason for making delay in lodging the same on the following day. On 10/5, I examined 5 numbers of witnesses. PW1 Minoti Telly did not state before me that the house of accused Jogoi Telly is situated at the bottom of the tilla and her house is on the top of the said tilla. And at the relevant time, the accused Jogoi Telly from his house asked her husband to go to his house, and accordingly, her husband went to the house of accused Jogoi. And then accused Jogoi alone assaulted her husband by means of a dove, inflicting blows on the back of the head. And remaining accused persons encircled her husband. And as a result of the assault, her husband fell down on the ground. And when she went near her husband, she found him senseless. And thereafter, she raised hue and cry. And hearing the same, Sorola Telly and Vaikuntha Telly came to the place of occurrence and saw the incident. Now, the 313, this is of Samru Telly. These persons have been acquitted. Babul has been acquitted. Next is Sahadev has been acquitted.
Total, how many persons were charge sheeted?
5, my lord, including present appellant. 313 of the present appellant starts at 32, my lord.
Yes.
PW1 Binoti Telly has stated in her evidence that the deceased Dilip Telly is her husband and their house is on the top of the hillock, while your house is on the bottom of the same hillock. What do you have to say? He says yes. PW1 has further stated that on the relevant day at about 2-3 p.m., you called her husband to go to your house, and accordingly, her husband went there, and then you assaulted her husband by means of a dove, inflicting blows on the head. And as a result of the assault, her husband fell down and died. Yes, I assaulted him with dove. PW1 has further stated that at the time the remaining accused person encircled her husband. What do you have to say at the piece of evidence?
Yes, it's in number 11 also, you said I killed him.
Number 11, he said I killed him. But Lordship will kindly read 15, my lord.
Hmm.
15, my lord, at page 36. The deceased Dilip always used to assault me and my uncles under the influence of liquor. On the relevant day, he hired some persons from so-and-so, and being armed with gun came to my house and attacked me and asked me as to why I filed a criminal case against him. Then I took out a dove from my house and inflicted blows on him. The remaining accused persons are not at all involved in the occurrence, and they are not present there. They are innocent. Now, this part of the story, my lord, has also not been investigated by the police, whether there was indeed a criminal case filed by the appellant here in my lord, or that he had exercised his right of private defense. And sadly enough, my lord, the cross-examination part also, there is not even a suggestion given that he had come to the house with a gun. Because had that been there, my lord, I think I could have argued that line, that yes, it was a right of private defense. Although, my lord, the injuries are very, very grave. At the back of the head and also at the legs, my lord, both legs. So the prosecution may very well say, my lord, that I have exceeded even if I argue that it is a right of private defense, that I have exceeded that. But fact remains that, my lord, no one has said anything. Of course, all the witnesses are the relatives, my lord. And there are discrepancies, because the wife says that I raised the hue and cry, then my mother and father came,
So what is your basic submission here? Are you saying it's a case of acquittal?
It's not a case of acquittal, my lord.
Then
Only line of argument which I can take is the right of private defense.
but are there materials to?
Yeah, that is also difficult. No, not even a single sentence, not even a suggestion that this was the real cause. Because had he come, and another difficulty which I am facing, my lord, the place of occurrence is not at my house. Had it been inside my residence, that someone has come with a gun to attack me. And this has been dealt with by the Honorable District Judge, my lord. May I just point out that?
Let us see which part, page number.
I'll just point out, my lord.
Yes.
Page 48, paragraph 22.
Okay.
Because prior to that, my lord, the evidence has been, whatever I have read, my lord, that has been reproduced, my lord.
Let us just see let us read from para 22.
Lordship may also read paragraph 20, my lord.
All right.
Now, the learned judge, my lord, he says that PW2 is not reliable, PW1 is not reliable. But 2, 3, 4 says that they have seen. And in the cross also they have, in the cross also, my lord, they say they have seen. Rather than asking, the suggestion should have gone that whatever you have said it is false, you could not have seen it. But in the cross also, lordship, I have just now read, cross also,
So
lordship.
PW 2, 3, 4 have been examined as eyewitnesses.
Eyewitnesses.
They have said that they have seen the
They have
occurrence.
seen.
But there are contradictions in there.
Contradiction. The timeline is also,
But are these material contradiction?
without the 313, I would have argued, my lord, that yes, it is material.
What makes things difficult for you is the 313
Yes.
admission.
Although, my lord, it cannot be, this 313 cannot form the sole basis of the conviction.
No, but it can lend assurance to the
Exactly. And moreover, my lord, in the cross-examination of those witnesses, not even a suggestion has gone that you could not have seen it. Because if lordship sees the timeline, the wife says that I heard a hue and cry, I went there, I saw him inflicting the blows. That in the cross-examination, she says she.
So the contradiction appears to be on one count. Who came there before whom?
And whether they had seen it also, I would respectfully say. Because if the version of the PW1 is to be believed, that she saw, and when she went to the place of occurrence, the deceased was already lying there.
All right, so let us test this from another angle. Let us take it that none of them had seen the occurrence. But it is not in dispute that they went to the place of occurrence immediately after the incident.
Yes.
Correct. So that's why we asked her to respond. If not eyewitnesses, they are the witnesses who appear to have immediately reached the place of occurrence, and they have seen the accused present there, along with the dao. Correct.
Although they don't say specifically.
And
that
they
have seen the doubt.
say so, but they have seen the accused
They have
present
seen the
there. And at that time, the victim was lying there in a seriously wounded condition. Right. Now, this part has been established from the evidence. It happened in the place of occurrence, time, the presence of the accused person there, the fact that the deceased was badly injured, ultimately established that it was homicidal death, the presence of the accused, and finally his admission in 313 that he is the one who assaulted and killed. If these three things are seen, if these things are seen in one chain, then does it leave any scope for this court to overturn the conviction of the
Very less, madam.
appellant?
Very less.
Huh?
Very less, madam. I have to be fair. Only thing I could have argued that the right of private defense. Had it been one blow, because lordship has seen the injuries, my lord. He has also hit the person in the legs.
No, but how will you also argue that? Because there is nothing to show that the deceased was carrying any weapon.
No. And that is how it has been dealt with by the learned district judge, my lord, saying that the 313 he says that he had gone there himself carrying a gun and another hired people, but no one was there. And if he had assaulted him with a dao, then they would have also retaliated. Paragraph 22, my lord. If I may just read, my lord.
Yes, you can read whatever.
My lord,
Read
22,
from
ma'am.
page 20 or para 20?
Para 20.
All right. Yes.
Para 20 is actually, my lord, regarding the involvement of the other accused. But here the learned court below, my lord, has dealt with the evidence of everyone.
Para
Now-
22.
Well, lordship made it 22 first.
Okay.
The accused while merriment, the accused while was examined under section 313 of the CRPC, though admitted that he has killed the deceased Dilip Teli, but explaining the circumstances, he has stated that the deceased Dilip Teli, always under influence of liquor, used to assault him and his uncles, and on the relevant day, Dilip Teli hired some persons who, being armed with gun, came to his house and attacked him and charged him as to why he had filed the criminal case against Dilip Teli. Then he took out a dao from his house and inflicted blows on Dilip Teli. The said contentions of the accused is found very inconsistent and incompatible with the circumstances under which the offense was committed. The defense side did not put a single suggestion during cross-examination to the effect that the accused, in order to exercise his right of private defense, inflicted the dao blows on the deceased, or he committed the incident in the heat of passion upon a sudden quarrel. It is stated by the accused that when the deceased, along with his party men, attacked him being armed with gun, and then he took out a dao and assaulted the deceased. But it is an utter surprise that when the accused was inflicting several dao blows on the deceased, the hired persons being armed with gun were merely witnessing the same silently. Therefore, the statements made by the accused as to how the deceased, along with his party men being armed with gun, attacked him is not at all trustworthy and believable. In view of the above, it has come to the fore that the accused Jogoi Tel intentionally committed the murder of deceased, and the said act of accused does fall within the purview of any of the exceptions as enumerated section 300, and thus the accused has been found guilty of committing murder of deceased. But I could have argued out regarding 304, my lord, had it been a single blow that as
Out of some fear or
or something, he had
sense of intimidation.
he had. But
There were 5 injuries inside.
5 injuries and lethal, my lord, even the skull has been fractured. And the injuries in the legs, my lord, that is also very difficult to explain. The cut injuries on both ankles. Maybe, my lord, he went wild, my lord, with the dao. Also, my lord, had it been a case that he was fired upon, because no gun was seized from the site.
Yes.
That is also another issue, my lord. Without the 313, my lord, maybe there was discrepancies. But even in the
Without
cross,
the 313, we would have to work harder.
my
That's
lord,
the only thing.
that
The judges would have been required to work
Work
harder
harder.
to write a judgment. That's the only thing. If there is anything else, then you can argue, we'll hear.
no, my lord, that will be all.
So
That's a right of private defense. How it is.
what is this right of, let us see the requirements.
I had a judgment, my lord, 96, my lord.
IPC, give it.
Wait,
What is exception 2 of
Section
Section 300.
General exceptions.
197. Madam, there is a judgment of the apex court, madam, 2019-15 SCC, page 117.
Hmm. Just a moment, let's just have a quick look at exception 2.
Hundred also, madam,
So it says without premeditation.
without. Here it is, appears to be without premeditation.
Now, how can you say that?
Oh, of course, because
He came
there
out
is
in the
evidence
road.
that he had called him to the house. And he admits in 313, yes, I had called him to the house.
And then he came out of the house and assaulted the victim in the road.
In the road. In
And
three
when he
thirteen also,
came
my
there,
lord.
he was armed with that dao.
Yes, and in the 313 also, in the first question, admits, oh, no, in the first question, it was regarding the distance, not that he had called him. No, I think in the second
Yes.
question,
Which judgment you want to rely upon?
this is 2000 Sukumaran, my lord. Para 32 of the judgment. It relies to the judgment of Darshan Singh, my lord. Laid down the following 10 principles after analyzing section 96 of to 106, which are read as under. What are the 10 principles? Self-preservation is the basic human instinct and is duly recognized by the criminal jurisprudence of all civilized countries. All free, democratic, and civilized countries recognize the right of private defense within certain reasonable limits. The right of private defense is available only to one who is suddenly confronted with the necessity of averting an impending danger and not of self-creation. A mere reasonable apprehension is enough to put the right of self-defense into operation. In other words, it is not necessary that there should be an actual commission of the offense in order to give rise to the right of private defense. It is enough if the accused apprehended that such an offense is contemplated and it is likely to be committed if the right of private defense is not exercised. The right of private defense commences as soon as a reasonable apprehension arises and it is coterminous with the duration of such apprehension. Coterminous with the duration of such apprehension. It is unrealistic to expect a person under assault to modulate his defense step by step with arithmetic exactitude. In private defense, the force used by the, now this is important. In private defense, the force used by the accused ought not to be wholly disproportionate or much greater than necessary for protection of the person or property. This may go against the appellant. It is well settled that even if the accused does not plead self-defense, it is open to consider such a plea if the same arises from the material on record. The accused need not prove the existence of the right of private defense beyond reasonable doubt. The penal code confers the right of private defense only when that unlawful or wrongful act is an offense. A person who is in imminent or reasonable danger of losing his life or limb may in exercise of self-defense inflict any harm, even extending to death of his assailant, either when the assault is attempted or directly threatened. So these are the
ingredients do not fit into this.
difficult to argument that it fits. Had there been some amount of some line of cross-examination, some materials laid, then maybe, my lord.
Okay, what we wanted to ask you is, you think for another 5 minutes,
My lord.
just break for 5 minutes. If you think you want time to look at any other angle, then we can give you time, 1 or 2 days time. Otherwise, we'll hear and deliver the judgment.
Then lordship will give me 2 days time. I want to explore the 304 part, if it can be,
304.
if it can be.
What I see in this particular case is that barring 313, if we can show there is no witness who can be termed as an eyewitness, then we will have to go to the circumstances because 313 cannot be the basis. So eyewitnesses, what I find is daughter said mother came late. Mother said I have seen.
There is
There is.
contradiction.
There contradiction. There can be a situation like they had seen from a distance.
Yes.
Because it is at the bottom of the tila and it is in the front of the house. It is an open space perhaps. So they must have seen from a distance.
But it appears that there is corroboration on 3 aspects. First, as regards the place where the occurrence took place. Second, that the victim was found lying there in an badly injured condition. And third, the presence of the accused. These 3 circumstances come in a chain. That much appears to be well established from the testimony of these 3 witnesses, PW 2, 3, and 4.
Presence of the accused
Not
They-
established.
No, not at all.
not established because they said accused had hit. That accused trying to flee away, accused, somebody apprehended, he was there standing. Nobody had said that. If we can show, no, he had not seen, then those all eyewitnesses go. But what I said, they must have seen from a distance. Then when they reached the place of occurrence, they found him lying injured. That can be a situation. But then they did not say it that way. That while we were rushing towards the place, we saw from a distance. They said we rushed to the place and we saw. They cannot see actually.
And then what makes matters really difficult is that he has admitted that he is the one who.
He has admitted. So we leave aside eyewitnesses part, then we go to circumstances. Then if we find circumstances are enough, then 313 will link. That can be a situation.
Do you have any judgment on this, how this 313 statement admission is to be?
Yes, I have, but
I
Today,
also have it, my lord. Not
it becomes a circumstance that I can show.
we'll take it up on Monday,
Lordship.
my lord.
Monday again.
Monday.
You please have some decisions
Yes,
on
yes,
this.
I.
And it will not be res gesta if your lordship had said, because res gesta, they themselves said we had seen. Res gesta would come that eyewitnesses have told him immediately after the occurrence, forming a complete chain.
But merely because the contradictions are there, can we reach a conclusion that none of them had seen the occurrence?
That can be a situation.
We'll
Then
take
we
it up
come to circumstances.
on Monday?
Tuesday, Monday.
Acha.
Tuesday.
Then Tuesday.
No, Tuesday, there is a part heart matter, my lord. Can it be on Wednesday, my lord? It is not inconvenient.
Let it be on Tuesday, we'll accommodate you.
My lord.
This will in any case not take much time. We have seen
No,
the facts.
not that much.
We have already seen the facts. Now-
Yesterday, Mr. Azad Ahmed had placed a case on ocular evidence.
Mhm.
That seems to be a nice one. How to see whether they have actually seen. That judgment also I'll bring.
We'll also, all the witnesses on the other hand, also interested witnesses. One is the mother, the other is the father, one is the brother, and one is the uncle.
The problem is the accused says, I have done
That is the difficult.
What to do?
That
with
is the difficult.
All right, Miss Meghali Burman, what is your matter? You are ready? How many witnesses?
14. But
Huh?
all are not, about 14 witnesses there, but all are not necessary.
All are not?
All are not necessary to taken care of. It is 3-4 witnesses are there.
The regular opinion. That means. May I please, your lordship?
Yes.
It's a conviction against. Appeal against the conviction, lordship, about 12 years, lordship. Under NDPS Act, lordship.
Yes.
Lordship, here 2 person convicted, lordship. And date of occurrence is 29/11/2015, and since 2015, lordship, on the date of arrest, they were inside the jail, lordship. FIR is at page 5, lordship.
Yes.
Mary, lordship. In connection with the aforementioned Kamakya GRPS OP GD entry number 589 dated 29/11/2015, informant Nur Mohammed informed me over phone around 5:45 AM on 29/11/2015 that train escort duty party RPF HC Narayan Das and his staff who had been on duty in down Busy Express had handed over to him 3 black bags containing packets of ganja-like substances wrapped with polythene, along with 2 suspected passengers who supposed to have carried those substances in that train at the main entrance of platform number 4 of Kamakya railway station. On receipt of the information, I went to the place of occurrence and found 3 black bags containing 4 packets having some substances suspected to be ganja. 1 packet was found wrapped with black polythene, while the other 3 packets with green polythene. Thereafter, the packets were weighed in presence of witnesses and total weight of the packet was found to be 35 kg. Then I seized each of the each of those packets of preparing separate scissor list and taking samples from those packets for official examination. I obtained the signatures of the witnesses, interrogating the two suspects who had been handed over to me by RPF. I could know their names to be Muhammad Malbar Khan and then Sri Ratan Ghosh. They confessed that they had carried the said ganja-like substances to Kamakhya railway station from Dimapur with a view to sell the same to ganja addicts. Both of them were taken to outpost along with the 3 bags and handed over to the insurers. Thereafter, Lordship, in this case, 5 witnesses examined, Lordship. PW1 is the informant. PW1 is at page 12. 22, 20, commercial, 35 pages. So, page 12 is the informant, Lordship.
Yes.
On 29/11/2015, I was working at Kamakhya Outpost as Sub-Inspector of Police. On that day, in charge of the aforesaid outpost, Sub-Inspector Dinesh Medi received an information from Nayak Nur Muhammad Ali, who was on night duty of Kamakhya railway station, that some ganja has been found in possession of some person or passengers coming in Busy Express from Dimapur, and accordingly, after receiving the said information, Inspector Dinesh Medi asked me to go to Kamakhya railway station. Accordingly, as per the direction, I went to Kamakhya railway station at platform number 4 by making ZD entry. Exhibit 1 is the certified copy of ZD entry number 589 dated 29/11/2015. After going to Kamakhya railway station at platform number 4 near entrance gate, Nayak Nur Muhammad Ali, Havildar RPF Narayan Das handed over the 2 accused persons, namely Malbar Khan and Ratan Ghosh, standing in the dock, and 3 numbers of bags containing ganja. Havildar Narayan Das told while he was on escort duty in the Busy Express, he found the 2 accused persons getting down from the train having the said bags in their hands. On suspicion, both the accused persons were apprehended, and after opening the bags in their possession, found the same containing ganja. After getting handed over the accused persons and the 3 numbers of bags, I queried the accused person, and on being queried, both the accused person confessed that the said bags belongs to them, and I opened the 3 bags, and after opening the same, all the bags were found containing ganja in 4 packets. 1 bag was found containing 2 packets, and other 2 bags were found 1 packet each. 1 packet was found being wrapped with green color polythene, and other 2 packets were found being wrapped with black color polythene. After being handed over the 3 bags and the 2 accused persons, I informed about the same to the officer in charge, GRPS Guwahati, Sri Pradeep Talukdar, Inspector, and accordingly Inspector P. Talukdar authorized me to take necessary steps as per the provisions of NDPS Act. Exhibit 3 is the authority letter, and Exhibit 2(1) is the signature of Inspector Pradeep Talukdar, which I know weighed. Thereafter, I weighed the said ganja by taking manual weighing balance or scale from the nearby scrap dealer named Sri Guddu Basfar. Exhibit 3 is the scissor list by which the weighing balance scale was seized. After weighing the entire ganja found in 4 packets from the possession of the accused person in 3 bags, it was found to be weighing 35 kg in total. After weighing the ganja, it was seized along with the 3 bags which contained the same. Exhibit 4 is the scissor list by which I seized the ganjas along with the 3 bags. Exhibit 41 is my signature. Therefore, I took sample from the seized ganja, the place of occurrence in presence of 2 witnesses, and then took signature of the witnesses on the said sample. Thereafter, I handed over the accused person seized ganja and the sample being drawn by me of the seized ganja to the in-charge Kamakhya GRP outpost, and then lodged written FIR at Kamakhya GRP outpost. Exhibit 5 is the FIR. Exhibit 6 is printed form of FIR. All seized ganja was deposited by me in GRPS Malkhana by MR 71/15. I have seen all the bags before the court today which were seized from the position of the accused person containing ganja in 4 packets. Then material exhibit lordship cross. On the date of incident, I was having duty at Kamakya outpost. The bags were handed over to me by CRP office staff Nayak Nur Muhammad Ali and RPF Havildar Narayan Das at about 4:45 AM. As per Nur Muhammad Ali and Narayan Das, the said bags were found inside the train having suspected ganja. During then no person was there inside the train. Havildar Narayan Das, after finding the bag, saw it after opening the same. I do not remember the exact time when I was given authority by the officer in charge GRPS Guwahati GRPS office is at 13 kilometers away from railway station. Exhibit 2 authority letter does not maintain the GD entry or any time of authorization. I do not remember the exact time from which I started my work as EO inquiry officer. I seized the balance or scale from the scrap shop situated about 10 meters from the place of occurrence. The ganjas were seized by my staff. I do not remember the names of the staff. There was only one staff present, namely Nur Muhammad Ali. The seized ganja were weighed 4 times as there were 4 packets seized using the seized balance or scale. The weight used to measure the 35 kg of ganja was weighing 6 kg. I have marked the seized packets. I drew the sample. One sample drawn by me, which was drawn in duplicate. Each sample was drawn weighing 24 grams. The aforesaid samples was weighed by Nayak Nur Muhammad Ali. I do not know where from Nayak Nur Muhammad Ali weighed the sample. I have not seized the balance by which the sample of 24 grams was weighed. I drew sample from one packet from the bag marked as material exhibit 3. I did not take any signature of the accused on the sample being drawn by me. I have also not put my signature on the same and also have not taken the signature of the concerned officer in charge. I have to drawn the facsimile of the seal put on the sample and also not drawn the sketch map of the place of occurrence. I handed over the seized article to the officer in charge GRPS Guwahati. I have not recorded a statement of the accused person. I deposed today as per information being received from Havildar Narayan Das of RPF. This is not the fact that I deposed falsely today. The GD entry number mentioned in para 3A of exhibit 6 is not found by in the record. Then exhibit 2, PW2. PW2 is the FSL expert, my lord. His cross part I'm reading, lordship. At page 19, after received the said sample, it was in joint custody of divisional in charge and myself under lock and key, out of which one key kept with me and another was with divisional in charge, and in my report I have mentioned the name of the test which I have performed. I have not seen remnants of the sample which has been sent back to the concerned authority and is not being produced in the court today. Then PW3, 3 and 4 is important as because Lordship PW1 stated that PW3 and 4 handed over all the articles and the accused to him, Lordship. So on 28/11/2015, I was posted at Kamaikya police outpost. On that day, I was on duty at night from 10 PM. I was performing night duty at Kamaikya railway station. I know the accused person on that day at about 4:30 AM when the Brown Busy Express was standing at platform number 4 at Kamaikya railway station. Then RPF party called me over phone that 2 persons with ganja were apprehended by them. Accordingly, I went to platform number 4 and found the accused person with bags caught by RPF personnel. I therefore informed my in charge of the outpost immediately, and in the meantime, one inspector of RPF arrived at the spot. Accordingly, my in charge deported SI Busha, who came and took the accused person with Ganga to the police station. IO examined him during the investigation. On the fateful day, RPF personnel handed over both the accused along with the 3 bags to me. The RPF official did not consist of any ganja gazetted officer. I was not aware that from where the accused were apprehended by RPF. On the railway platform, the RPF inspector opened the bags and I saw the ganja in the bags. I did not go to the Thana along with RPF official and the accused person. It is not a fact that I did not know about the occurrence of the case. I have not seen the articles today in the court, PW4. I know the accused persons on 28/11/2015. I was at train escort party and was traveling in BG Express train from Dimapur to Kamakya railway station. When the BG train came to Kamakya railway station, about 12 passengers caught the accused person with 3 bags and called me as in charge of RPF escort party to search. Accordingly, I rushed to the spot along with my staff. I found the accused held by the public, and I opened the 3 bags carried by accused persons which contained ganja, and accordingly I took bags with accused persons Kamakya railway station and informed the GRPF. When the GRPF officials came, I handed over the accused along with 3 bags. The GRPF official seized the ganja. The accused was found by the public at Kamakya railway station. The GRPF official took the weight of ganja, which weighing to 35 kg. The weight was taken by manual balance in instrument. Exhibit 4 is the scissor list and cross. Initially, the public apprehended the accused along with 3 bags at Guwahati railway station. My duty was to go to Kamakya railway station, and as such, I went there. I was not accompanied by the gazetted officer. I handed over the accused along with the bags to the constable of GRPF. I was present when the weight of the ganja was taken by GRPF at Kamakya railway station. The ganja packet in polythene packets and kept in the bags of the accused person. When the weight was taken, the polythene packets were not open, and as such, it is suspected that the packets containing ganja. GRPF official inspected the polythene packets and confirmed it containing ganja. I was not aware if the weight of the ganja was taken in presence of gazetted officer or not. I have not seen the seized ganja and bags in the court today. Then IO PW5 lecture. Very good.
Yes.
On 29/11/2015, I was posted at Kamakya GRPS. On that day, the OC Pradeep Talukdar entrusted me to investigate in the case. Prior to that, the RPF patrol party informed to our OC that during patrolling at Kamakya railway station, 2 persons along with the 3 bags containing suspected ganja were apprehended and sought for police intervention. Accordingly, the OC authorized Sri Mahesh Baisya, SI of Police of Kamakya GRPF. Accordingly, Mahesh Baisya went to Kamakya railway station and seized the contraband article as per law and took the accused person along with RPF official and produced before me. During investigation, I examined the witness and the accused person. The accused confessed that that they have brought the contraband articles from Dimapur from the purpose of selling. I arrested the accused and forwarded to court. I sent the contraband sample for FSL examination. I received back the FSL report which gave positive test for cannabis. At the end of the investigation, I informed the higher authority and finally submitted the charge sheet against the accused person. Exhibit 9 is the charge sheet. Cross. Right, Exhibit 2, Mahesh Vaishya was authorized to search and seizure purpose. There is no GD entry number in Exhibit 2. As per Exhibit 1, contraband were handed over to me by Nur Muhammad Ali Havildar and Narayan Das Head Constable RPF. Nur Muhammad Ali had shown me packets containing ganja by opening the packets. I have not prepared any seizure list. I did not draw up any sample. I have not seen the seized contraband articles along with the samples in the court today. I sent the sample on 30/11/2015. I draw up the facsimile of the sample. The remnants of the sample are not produced before me today. I cannot say how the weight of the sample of the contraband article was taken by Mahesh Vaishya. I received the sample package from Mahesh Vaishya and accordingly I sent the same to FSL without taking weight of the sample again. I recorded the statement of the witness at the police station. I filed Exhibit 9/17/2016 with CS numbers under Section 20A/29 of the NDPS Act. It is not a fact that I have no idea about the provision of Section 20A of NDPS Act and file against the accused falsely. These are the witnesses of the prosecution on the basis of which the person is convicted about 12 years torture. In this case, the deposition of PW1 is not corroborated with PW3 and 4. PW1 deposed in his deposition, Lordship, that this two person found by the Nurmam PW4 and 3 at inside the railway train, Lordship. When in the cross, it is mentioned, Lordship, page number 15, Lordship, last two lines. As per last three lines, as per Nur Muhammad Ali and Narayan Das, the said bags were found inside the train having suspected ganja during then no person was there inside the train. He has stated, Lordship, because he is the authorized officer who to whom the investigation, first investigation was entrusted, Lordship. On the basis of the authorization, on the basis of this information, he went to the place of occurrence, Lordship, where the accused persons were detained by PW 3 and 4. And second line is Havildar Narayan Das at page number 16, first line. Narayan Das, after finding the bag, saw it after opening the safe. And then, Lordship, his role is quite different, Lordship, in this case. As seizing officer, Lordship, kindly see the paragraph number 6, page number 16, 4, Lordship. I see the balance scale from the scrap shop is situated about 10 meters from the place of occurrence. The ganja were seized by my staff, not by him. And I do not remember the names of the staff. He is the seizing officer, Lordship. It is the duty of the seizing officer to search and seizure and seize all the things, if anything recovered, any contraband recovered, Lordship. And his role is quite different here. And he recovered 4 packets of sample contraband, Lordship. He only, from the four packet, only 1 packet sample he received, and that was forwarded to the FSL, Lordship. And regarding the other part, Lordship, this case first informed to PW number 5. He is neither the officer in charge of any police station, Lordship, but he recorded the statement. And there is no evidence at all, Lordship, who received after receiving this information forwarded to OC, Lordship. I have seen the this page 49, Lordship, this authorization letter, Lordship. Page 49 at no point of time stated that after receiving the information from the PW5, he has made the authorization to make to entrust PW1 as seizing officer. With the page 49, page 48 is the extra copy of the GD, Lordship. And the Pradeep Kumar Talukdar officer in charge, he is not made witness in this case at all, Lordship. And another part of submission is that, Lordship, they have found these accused persons were found in a crowded place, and somebody stated that 12 PW4 stated that 12% arrested, caught by the public, and out of 12%, only these 2% where they have arrested, and then from the public, this seizing officer at no point of time made witness, Lordship, which is very mandatory under NDPS Act, Lordship. And regarding sample, Lordship, only one sample, from which packet it was recovered and in what condition it was kept in the custody, Lordship, that is also not established.
Yes.
PW4, his chief, he has stated, when the busy train came to Kamakya railway station, about 4 passengers caught the accused person with 3 bags and called me as in charge of RPF escort party to search. Then what about other 10-person, Lordship? That is not disclosed by anybody, Lordship. But this is not corroborated with PW1 also, because PW1 stated that PW4 and 5 informed him that these persons were inside the train and they found the bag. This bag was inside the train, and when there was nobody inside that. So these persons were arrested only on suspicion, Lordship. And one more question. Then, Lordship, samples collected on 29, and it was forwarded to the FSL on, Lordship, 1/12/2015. It was collected on 29 morning, Lordship, at the time of search and seizure as per their deposition, Lordship. But for about 3 days where they have kept these things, that is also not there. So after search and seizure, it is a duty of the seizing officer to hand over these things to the officer in charge of the police station, and thereafter it is the duty of the officer in charge of the police station to prepare an inventory as per Mohanlal Judgment, Lordship, 2016, Lordship, to prepare the inventory as per section 52A, Lordship, and it must have to produce before the magistrate by filing an application for a correctness of the same, Lordship. And that is also, that formality is also not done, Lordship. And though it is in the public place, but this is not the case that just after the search and seizure, these accused persons, just after getting the person, that search and seizure was made. After getting the person, they informed, then information was reduced into writing, and thereafter the proceeding start, Lordship, against the person. If there is a written down on information, then section 52 must have to follow, Lordship, the requirements of section 42. As per section 42 of the Act, Lordship, may I read, Lordship?
Yes.
Any such person being an officer superior in rank to a peon, sepoy, or constable of the Department of Central Excise, Narcotic, Customs, Revenue, Intelligence, or any other department of the central government, including paramilitary forces or armed forces, as is empowered in his behalf by general or special order by the central government or any such officer being an officer superior in rank to a peon, sepoy, or constable of the revenue, drugs control, excise, police, or any other department of a state government, as is empowered in this behalf by general or special order of the state, if he has reason to believe from person knowledge or information given any person and taken down in writing that any narcotic, drugs, or psychotropic substance or controlled substance in respect of which an offense punishable under this act has been committed, or any document or other article which may furnish evidence of commission of such offense, or any illegally acquired property, or any document or other articles which may furnish evidence of holding any illegally acquired property which is liable for seizure or freezing or forfeiture under Chapter 5A of this act is kept or concealed in any building, conveyance, or enclosed place may between sunrise and sunset entered into search and search any building, conveyance, or place in case of resistance, break open by door or and remove any obstacle to such entry, seize such drug or substance and all materials used in manufacture thereof, and any other article or any animal or conveyance which he has reason to believe to be liable to confiscate under this act, and any document or other article which he has reason to be believed may furnish evidence of the commission of any offense punishable under this act, or furnish evidence of holding any illegally acquired property which is liable for seizure or freezing or forfeiture under Section 5A of this act. Detain and search, and if he thinks proper, arrest any person whom he has reason to believe to have committed any offense punishable under this act, provided that in respect of holding of a license of or manufactured drugs, psychotropic substance, or controlled substance granted under this act, or any rule or under order made thereunder, such power shall be exercised by an officer or not below the rank of sub-inspector, provided further that if such officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for escape of any offender, may entered and search such building, conveyance, or enclosed place at any time between sunset and sunrise after recording the grounds of his belief. Second is important, Lordship, where an officer takes down any information in writing under subsection 1 or records grounds for his belief under the proviso thereto, he shall within 72 hours send a copy thereof to his immediate official superior. So in this case, this formality is not observed because written down information was there. They have written down the information.
So do you have any judgment which
Yes.
says if this formality is not observed, the conviction has to be set aside?
Yes, Lordship.
You have some judgment. You are aware?
No. On that point, I don't have. Otherwise, NDPS is all procedures.
Hmm.
And police officers, there are certain exceptions also. Taking down and all will not be possible in this particular case. They were detained by the public. They were detained by the passengers. They were informed. RPF people had to rush to the place of occurrence. They found it. They took them down platform towards the platform. Then they informed the outpost. And then the outpost people came, took an authorization letter from the OC. And then the procedure started. There has to be some exceptions.
Do you have any decision?
Lordship will take it
Well-
up on Monday or Tuesday. I'll get those decisions. We are
Constitutional
not
bench
used to
judgment is
doing
there,
all these
Lordship.
NDPS matters.
Lordship, constitutional bench judgment is there, Lordship, regarding this.
Hmm.
Karnal Singh, and thereafter also, Lordship, Karnal Singh is in 2009. Thereafter 2013 also there, Lordship.
She is conversant, she has been doing NDPS matters since long. We are not very used to, so need some time.
All right, letter.
Lot.
letter complete.
Can be on Monday, Lordship.
We can
You want to,
finish.
you finish up your.
Lordship. I have only one on copy and other part also I will submit if on next day in that case. But the mandatory section I am explaining, Lordship. Regarding this, Lordship, 42 is there, what my learned friend is said, Lordship. That is not correct proposition of law.
Ms.
Because
Jahan, you please take note of what she's saying. huh?
section 42, I'm stating
Yes.
about section 42.
42, that's what I'm saying. There is a proviso in section 42.
So today you take note of
Lordship.
it and then you meet the arguments.
Lordship, section 40, in regards to section 42, Lordship, what my learned friend is said, that one person fought by the public, that thereafter RPF person came to the place of occurrence, and then he was detained by RPF officials. That part is okay. If RPF official, he himself conducted the search and seizure, there the application of 42 will not be there. But thing is that after caught by the RPF officer, he informed to the office GRPS officials. They reduced into writing, they prepared a GDNT. After that, the procedure starts, Lordship. This proceeding start after that, Lordship. That means, as per Colonel Singh's judgment, if there is any information, if police is in hurry also, in that case also subsequent compliance is be acceptable, Lordship. That is not done in our case. After reducing to writing, he must have to inform to the superior officer as per this section 42. Section 42, if not complied, then vitiate the trial, Lordship. This is the first requirements of the case, Lordship. And then, Lordship, 52A. 52A, kindly go to Lordship. For a moment, Lordship. May I read, Lordship?
Yes.
And nowadays, Lordship, 2016, in Mohanlal judgment, it has been decided by our apex court, Lordship. 52A. Disposal of seized narcotic drugs and psychotropic substances. Thereafter, Lordship, SOP also they have published, Lordship, by the central government, Lordship. The central government may having regard to the hazardous nature, 52A. Vulnerability to theft, substitution, constraint of proper storage space or any other relevant consideration in respect of any narcotic drugs, psychotropic substances, controlled substances, or conveyances by notification in the official gazette specifies such narcotic drugs or psychotropic substances, controlled substances, or conveyances, or class of narcotic drugs, class of psychotropic substance, says class of controlled substance or conveyance, which shall, as soon as may be after their seizure, be disposed of such officer and in such manner as that government may from time to time determine after following the procedure hereinafter specified. Where any narcotic drugs, psychotropic substances, controlled substance, or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53, the officer referred to in subsection 1 self-prepared an inventory. It's mandatory, self-prepared an inventory of such narcotic drugs, psychotropic substances, controlled substance, or conveyances containing such details relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identifying particulars of the narcotic drugs, psychotropic substances, controlled substances, or conveyances, or the packing in which they are packed, country of origin, and other particulars as the officer referred to in subsection 1 may consider relevant to the identity of narcotic drugs, psychotropic substances, controlled substances, or conveyances in proceeding under this act and make an application to any magistrate for the purpose of A, certifying the correctness of inventory so prepared. taking the present in the presence of such magistrate photograph or such drugs, substances or conveniences and certifying the such photograph as true. C, allowing to draw representative samples of such drugs or substances in the presence of such magistrate and certifying the correctness of any list of samples so drawn. 3, where an application is made under subsection 2, the magistrate shall, as soon as may be, allow the application. 4, notwithstanding anything contained in the Indian Evidence Act or the Code of Criminal Procedure, every court trying an offense under this act shall treat and inventory the photographs of narcotic, narcotic drugs, psychotropic substances, controlled substance or conveniences, or any list of sample drawn under subsection 2 and certified by the magistrate as primary evidence in respect of such offense. So that is not done in our case. The inventory must have to prepare, and that is the duty of the officer in charge. Here, one more, this is mandatory. Do 2 sections are mandatory under this act, Lordship. 42 and the 52A. And then other section, if recovery is from the body search, then the section 50 will be applicable, Lordship. And it is not a case of section 50, Lordship, because it is not the recovery of from the body. So, Lordship, the other is 55. Police to take search of articles seized and delivered. An officer in charge of police station shall take charge of and keep in safe custody pending the orders of the magistrate all articles seized under this act within the local area of that police station and which may be delivered to him, and shall allow any officer who may accompany such article to the police station or who may be deported for the purpose to affix his seal to such articles and to take samples of and from them, and all samples so taken shall also be sealed with a seal of officer in charge of the police station. Then, Lordship, with 55, after completion of search and seizure, after everything, Lordship, it is the duty of the officer in charge to submit a report under 57, Lordship. Report of arrest and seizure. Whenever any person makes any arrest or seizure under this act, he shall within 48 hours next after such arrest or seizure make a full report of all particulars of such arrest or seizure to his immediate official superior. So these are not followed by the neither by the seizing officer nor by the investigating officer in the entire case, Lordship. Then, Lordship, regarding sample, Lordship, though it is not mentioned in the act, Lordship, there is some SOP, Lordship, and standing order 1/89, Lordship. Standing order 1/89. That is mentioned specifically that from each packet must have to, if ganja, then 24 gram from each packet. Then it must have to forward it to the FSL, whether it is ganja contraband or not. That is not done in our case, Lordship. That SOP I will also place before your Lordship, and along with the judgment, Lordship. The judgment, Lordship, I need some more time, Lordship, regarding placing this judgment, Lordship. This apex court judgment I have not could not complete it, Lordship. This apex court judgment I have.
Let us see the impugned judgment here.
Lordship. At page, it starts from page 34, Lordship. The relevant portion starts from other part is regarding this deposition of the PWS, Lordship. It starts from 39, Lordship. Page 17, para 17.
Yes,
May I read, Lordship?
yes.
From the above evidence of the prosecution witnesses, it appears that there is no independent witness examined in the case. Thus, all the prosecution witnesses are official persons. They corroborate each other on material point in sequence of event of the case leading to discovery of contraband articles in the 3 bags of the accused person. But the accused person denied that some contraband articles were recovered from them. In 2015-17 SCC 554 Baldev Singh State of Haryana, it was held that there is no legal proposition that evidence of police official unless supported by independent evidence is unworthy of acceptance. Evidence of police witness cannot be discarded merely on the ground that they belong to police force and interested in the investigation and their desire to see the success of the case. Students, however, request that the evidence of police officials who are interested in the outcome of the result of the case needs to be carefully scrutinized and independently appreciated. 18. Now, thus, from above law, it is clear that the evidence of official witnesses needs carefully appreciation to assess their credibility. From the case record, it appears that it was PW4 who first detected the carrying of ganja by 2 persons who were held by the public passengers of train. There is no denial of the fact that PW4 was on escort duty in the busy express train running from Dimapur to Guwahati, Kamakya railway station on the fateful day. PW4 belongs to RPF organization which is deployed for the purpose of train security in general. Thus, he is not a member of local police. PW4 received the information that 2 persons were held up by local passengers for carrying suspected ganja in their luggages. Once he got the information, he rushed to the spot and found the accused person with 3 bags containing suspected ganja. After opening the same, and he immediately informed the local police. PW4 is found to be a Havildar of RPF. Learned counsel for the accused person submitted that the contraband was first detected by the official like PW3 and 4 who are not superior officer in rank to a peon, sepoy or constable, and PW3 did not record the information in writing so received by him prior to his proceeding to the place of occurrence. Thus, there is clear violation of provisions of Section 42 and 43 of the Act, and thus the investigation is vitiated under the law. Apart from that, the prosecution failed to examine any independent witness, whereas the occurrence took place at a public place like railway station, he maintained. Therefore, he submitted that the accused persons are entitled to be acquitted from the charge of the offense. Per contra, the learned additional public prosecutor submitted that public place includes railway station. He submitted that PW4 and neither any official had prior to no information of illegal trafficking of ganja in the train to reduce to writing. Sorry. PW4 only received an information that 2 persons were held up by the public passengers of train with 3 bags, and accordingly he rushed to spot and detected carrying some suspected contraband by the accused person in the bag. Therefore, recording of such does not arise. I'm sorry. Moreover, he submitted that since there was no prior information of such illegal trafficking of ganja, there is no need of any specific official above the rank of peon, sepoy or constable, unless PW4 did not sunk into action, the culprits would have escaped from the hands of law. Hence, there is no infirmity in the prosecution, he maintained. Again, it is placed on a record the decision with reference to witness of the prosecution, which is reported in Chandanza. It was held the criminal trial witness, police witness conviction of the basis of testimony of police officers whether permissible held yes. If testimony of police officers is found credible and trustworthy, corroboration by independent witness held not necessary. NDPS case, seizing officer and investigating officer being the same person. Criminal investigation whether vitiate no evidence to show if the accused were prejudiced. investigation not vitiated. It is already found that there is no independent witness was examined in that case. It cannot be denied that any of the police officials had prior information of illegal trafficking of ganja by two persons in busy express train on the fateful day. It was PW4 who is RPF official had first received the information of apprehension of two persons with bags. In that time, admittedly, PW4 had no prior information that those apprehended persons by some percentages had in possession of contraband substances. Thus, unless PW had no prior information, he has not bound to reduce the same information into writing. It appears from the evidence of PW4, he immediately rushed to the spot and after discovery of contraband substances in 3 bags of the accused persons, he informed the local police. Therefore, in absence of prior information, the case of prosecution is not hit under section 42 and 43 of NDPS Act. Apart from that, unless PW4 apprehended the accused persons with the contraband article in their bags, it was not possible for PW1 and other police official would not have able to catch the accused person with the contraband. Hence, the circumstance does not suggest that there is any illegality committed in the case. It appears from the evidence PW3 that he was informed by PW4 about the apprehension of accused person with contraband article. PW3 is the police constable and as such, he apparently informed the in-charge of GRPS immediately. There is constancy between PW4, 3 and 4 on the material point. There is no scope for PW3 to reduce the information into writing since he is a constable. Therefore, PW3 rightly reported it to his in-charge. Further, when PW3 received the information from PW4, he immediately informed his in-charge who entrusted PW1 to go to the spot. The evidence of PW1 shows that before leaving out to the spot, PW1 recorded the said information into writing by Exhibit 1, which is the relevant GD entry of the case. Therefore, it cannot be said that the information she received was not reduced to writing during the investigation in compliance of Section 43 of the NDPS Act. There is no dispute that PW1 received an authority letter from his superior officer to proceed in the case by Exhibit 2. Hence, PW1 was empowered and authorized to search and seizure of contraband articles. Further, the evidence of PW1 shows that he found the accused persons were handed over to him by PW3 and 4 with the bags containing ganja at the railway platform. Now it comes to the notice that there is no evidence on record that the personal source of the accused persons was not made at any point of time. Only their bags were searched without prior information. Hence, compliance of Section 50 NDPS Act is not necessary in the case. It appears that PW1, after receiving the accused persons with their 3 bags, collected a manual balance scale and took weight of the same. He also collected the samples of contraband articles on the spot for the purpose of official examination. PW1 also proved the seizure list of contraband by Exhibit 4. Apart from that, PW1 seized the manual balance by Exhibit 3. It is true that there was no independent witness for seizure of contraband articles from the accused person, but from the evidence 3 and 4, it cannot be disbelieved the version of PW1 at all. Moreover, it cannot be expected normally any local person present at railway platform. All the persons came to platform to move out to the destination. Thus, it was not possible for PW1 to get corroboration from any independent witness in the presence of seizure of ganja from the accused person at the railway platform. Thus, it is held that seizure is rightly proved by PW1 against the accused person. Thus, from the evidence PW1, which is corroborated by PW3 and 4 on every sequences of event that he recovered 35 kg of ganja from the accused person, which were kept in the 3 bags containing the ganja in 4 polythene packets to freezer. PW1 gave details of the method of drawing samples out of recovered ganja, which was sealed by him as confirmed and supported by PW2. It is also not in dispute that the seized ganja was kept in the Malkhana. It is correct to say that register of Malkhana was not produced to confirm it, but it is part of the police station. Its movement would create problem in normal functioning of police station. However, the MR number in the case so recorded affirms that contraband ganja was kept in safe custody of the police station. PW1 could identify the MR exhibit 124 produced during the trial. Further, the evidence of PW1 is supported by PW5, who investigated the case as per direction of official inches of police station. The evidence of PW5 shows that he sent the sample to FSL examination. Subsequently, he collected the FSL report, exhibit 7 and 8, which are proved by PW2. Apparently, there is no dispute that the contraband was cannabis. Hence, PW5 filed a search sheet against the accused person by exhibit 9. From the above evidence of prosecution witnesses, it is clear that the 35 kgs of ganja was recovered from the accused persons carried in 3 bags, which was duly seized by PW1. It is correct to say that no journey railway tickets were recovered by PW1 from the accused person, but the accused persons were caught with huge quantity of contraband ganja from railway platform and by railway passengers initially. Therefore, it is special knowledge of the accused persons regarding not possessing any railway tickets under section 106 of Evidence Act. It is burden of the accused persons to prove the fact why they were in possession of journey railway tickets. From the statement of the accused person recorded under section 313 CRPC, it appears that the accused persons took the plea that some passengers asked them to carry the bags under pretext to call a rickshaw, and in the meantime, the police caught them. They denied the possession of the bags containing ganja, and neither they wanted to say that they had no knowledge of contraband kept in the bags. Thus, it is burden of the accused persons to prove that there were not mental state to commit such crime as alleged by the prosecution. It is probable that they may be right since no railway tickets were recovered from them, which indicates that they might not travel by busy express train on the fateful day. But the version of 1, 3, and 4 does not corroborate the above claim of the accused person. The evidence of PW4, it was the some passengers who caught the accused persons for carrying the bag suspiciously, and thus it was informed to PW4, who was in the escort duty of busy express train. Had there been another person involved in the trafficking of the ganja by train, the accused person ought to have reported it to PW1 and 3 and 4 immediately, but the evidence on record does not disclose so. If there were the railway porter, they ought to have produced the relevant documents to show that they were in conscious possession of the contraband ganja. In the Baldev case of it was held that once the physical possession of contraband of the accused have been proved, section 35 of NDPS Act comes into play, and burden shifts to the appellant accused to prove that he was not in conscious possession of the contraband. In an instant case, also the evidence on record proves clearly that accused persons were found in illegal possession of 35 of ganja, which was seized from their possession containing the 3 bags. The pleas were taken by the accused persons to prove that they were not in conscious possession. They were not in conscious possession of the ganja, but accused persons failed to adduce any such evidence to draw a different view from the prosecution. Hence, there is no bar to presume under section 335 of the NDPS Act, and the accused persons were conscious of possession. The seized 35 kg of ganja carried in 3 bags. Thus, from the evidence on record, it appears that both the accused persons both involved in trafficking the contraband ganja, and they agreed to conspire to commit the crime together, but got red-handed. It is correct to say that there is apparent lapse in the investigation of the case, but insurance it was held that With the advancement of technology and availability of high-speed exchange of information, some of provision and DPS, including 42, have to be read in the exchange context. It is, if the evidence of the official witnesses carefully perused, it appears that they tendered natural evidence as per their duty. Mere absence of independent witness does not take away their reliability from every dimensions of the case, and thus the lapse so apparent in the prosecution case cannot disclose its credibility outright. There is no ground to disbelieve the version of official witnesses, particularly the evidence of PW4 is from different organizations. Similarly, if PW4 had tendered false evidence, he would not have been corroborated by local police official of the case. PW4 proved the seizure of contraband. In other words, there is no ground to disbelieve the version of prosecution witnesses who perform their respective official duties.
All right, all right. All right, so we'll continue. 15th. I heard Ms. Esken Argus,
15th.
counsel appearing on behalf of the appellant. Also, Ms. S. Jahan, learned APP Assam is present on behalf of the state. Arguments from the appellant side had remained inconclusive today. On the request of learned counsel for the appellant, this matter is directed to be listed again on 15/12/2022 as a fixed part.
Fair please, your lordship. In this matter, there are two accused, my lord. I am appearing for the second accused, and other named accused it is also reflected in Jail Appeal 41J/2022, my lord. Whereas another amicus is also appointed, my lord.
What has happened? That appeal has not been listed.
No,
No.
that is notice was issued. LCR is called for. Probably order was for.
It came up in
preparation
the
of
month of
paper.
September. It came up last
It was
occasion.
last occasion, 29/9/2022.
Then both the appeals should be
Yes.
taken up together. You take down heard Ms. M. Borman, learned amicus curiae appearing for the appellant. We have also heard Ms. B. Bhuya, learned senior counsel in APP Assam, appearing for the state. We are informed that another appeal arising out of the same judgment referred by a co-accused, which is numbered and registered as criminal appeal bracket jail bracket close J. 41/2022 is pending before this court, which requires to be taken up which requires to be heard analogously with this appeal. But this same matter is not in the list today. In view of the above, the registry is directed to list this appeal along with criminal AJ 41/22. After vacation,
My lord, because I am also praying that from
after the winter.
ensuing week, I have some training program, so I may not be able to come.
Item 5.
Lordship, this matter should not have come up for hearing. Paper book is not ready, your lordship.
LCR has also not been received, right?
LCR also not. received. Just for this.
Lordship, I've got a memo wherein all the evidences are annexed.
Is it ready for hearing?
Not this one. Lordship, it's not ready for hearing.
LCR is not. LCR not all for lordship.
Ms. L. Devi, legal aid counsel has appeared for the appellant. Ms. B. Bhuya, so for this state, it is submitted at the bar that LCR has not yet been received, and therefore this appeal has been wrongly listed for hearing today. So registry to verify and list the matter in the appropriate column after the winter vacation. Part 2, any ready matter?
Part 2.
I have item 10, my lordship pleases. I have item 11, my lord. If lordship pleases, I can. Item 11.
How much time will you require?
Not much, my lord.
8 witnesses.
Probably no interference is required also. My son has killed the father, my lord. Informant herself is a mother.
Then
my
we'll
lord.
do it next week.